the first episode of our Student Defense Programming. At K. Altman Law, we represent students across the country, from kindergarten through graduate school, even medical schools and law schools. We represent students in discipline cases, academic integrity matters, Title IX proceedings, and even issues related to civil rights. Now, most families send their kids to school assuming that if something goes wrong, the adults will sort it out, and then everyone will just move on. But if you're listening to this, chances are you have discovered the other side of school. You know that side with discipline letters, student code of conducts, Title IX notices, academic integrity charges. Well, maybe your child is in fifth grade and you just heard the word expulsion for the very first time. Maybe you have a college student and your college student just forwarded you an email that says notice of allegations. And when you read that, your heart dropped in your shoes. Well, this is Legally Blind Justice, brought to you by K. Altman Law. I'm your host, Dr. Amanda Stewart. Now, all of a sudden, it feels less like school and more like a courtroom you never wanted to visit. Today, we're going to slow down and put it in plain English. We'll talk about how discipline really works in K through 12 and in college, who makes the decisions, what's due process, what does that term mean, and look at situations and see, is it truly minor or is it a situation that could follow a student for years? Now, over the years, one thing has been very clear to us. Most families don't understand how these processes actually work until they're already in trouble. And by then, they're usually up against tight timelines. And the system speaks their own language. Now, to help us translate that language today, I'm joined by our Assistant Director of Student Defense here at K. Altman Law, Dr. Robert Wright. Dr. Wright works every day with students and families who's trying to navigate discipline systems that they didn't even know existed until the stakes were already high. Rob, thanks for being here today.
Thanks, Amanda. I'm glad to do this. This is definitely a conversation that I wish every family could hear before they ever get that first scary email from a school.
I agree. Thanks for being here too. Now, let's start with a story. Well, actually, let's start with two. Let's first meet our first student. Her name is Maya. She's an 8th grade student at a public middle school.
Okay.
She's never been in serious trouble before. Now, one day in the hallway, there's an argument. The argument turns into a shoving match. Someone records it on the phone. Now, by the end of the day, the assistant principal is calling Maya's parents. And during that call, the assistant principal mentioned a possible suspension for fighting and threatening behaviors. Now, second, our student's name is Alex. Let's meet Alex. He's a sophomore in college, and during an online exam, the professor notices that Alex's answer patterns look similar to another student's. The professor files an academic integrity report. A week later, Alex gets an email from the university's conduct office. And in that email, it states, you are charged with violating the academic honesty policy. Possible sanctions include failure of the course, academic probation, or suspension. Now, I know you agree, Rob, that these are two very different students, two very different settings, but the same sinking feeling in the pit of your stomach. Now, Rob, based on your perspective and experience, what's the first thing these families need to understand about the system they have just stepped into?
Well, the first thing that they both need to understand that in neither of these cases is the system informal, even if it looks like that or even if it's kind of presented that way. In the first case, with the elementary school, in Maya's case, you might feel like it's just school. We'll talk to the principal. We'll sort it out. But if the school puts a suspension or an expulsion on her record, that can affect where she goes to high school, how other schools are going to view her, and basically how she's going to be treated in the school system going forward. In Alex's case, at the college level, it would be easy for him to think it's just an email. I'll explain it to the professor. Everything will be fine. But a lot of colleges take academic integrity findings very seriously, and they're recorded in internal files and can show up later when you're trying to maybe transfer or applying to graduate school, which certainly a lot of people are doing today, or trying to get licensed in a certain profession. So the first message is to make sure you know this is not just a casual conversation. It's a process. It's a formal process that has timelines and can have long-term consequences. So you want to understand that before you sign anything or say anything.
Okay. Thanks, Rob. Now, let's break these systems down because we talked about K through 12 and we talked about college. So let's start with K through 12. When we say school discipline for K through 12, what are we really talking about?
Well, we're talking about a range of actions schools can take when they believe a student has violated a rule. On the mild end, you have things like warnings, detention, loss of privileges, that kind of thing. On the more serious end, you have in-school suspensions, out-of-school suspensions, long-term suspensions, expulsion, and in some districts, even alternative school placements. The rules are usually written down for this kind of thing in a formal code of conduct or in a student handbook. And those rules in those places will typically define what they count as fighting, bullying, harassment, disruptive behavior, that kind of thing. And it'll also usually include kind of a list of what are the potential consequences for these kinds of things.
Yeah. And on top of that, there are laws and constitutional rights that apply differently in public and private schools. So that's a whole nother issue. Now, at a high level, what's the difference between a public K through 12 school and a private K through 12 school when it comes to discipline?
In public schools, students have certain constitutional protections because the school is part of the government. So there are very strict rules about notice, the chance to be heard, how extreme punishments like long-term suspensions and expulsions are handled, and those kinds of things. There are also very specific federal protections and regulations for students with disabilities. In private K through 12 schools, students usually don't have the same level of constitutional protections, but they do have rights. They have rights based on contracts, because you're making a contract with the private school, and school policies, and then sometimes state laws and federal laws do apply to private schools too. The process can be more discretionary, but the school is definitely expected to follow its own rules.
Exactly, I agree. So in Maya's case, when her parents gets the call, from the assistant principal about suspension, the first step is to figure out, is this a public school or a private school? What do the written policies say? And what procedures apply before the school can take serious action?
Exactly. And you want to see those policies in writing, not just rely on what somebody says over the phone.
Exactly. And most schools will have that information posted on their website. So it's very important to review that. Now, when we were talking about Alex, we know for Alex, Rob, that was college, university level. And let's talk a little bit more about their conduct systems. So let's talk about Alex and the college world. This is where things often surprise families because college discipline feels like a legal system built inside of a school. Robert, in most colleges and universities, who actually runs the discipline process?
It can vary from one place to another, but usually it's some combination of the dean of students office, a specific student conduct office, or an academic integrity board, something like that. Specifically for Title IX and sexual misconduct cases, there's often a separate Title IX office or a Title IX investigator that's basically determined according to federal regulations. So at a college or a university, instead of a principal, you might have a conduct administrator or a hearing panel. instead of a detention slip or something, you'll get a formal charge letter. And instead of, 3-day suspension or something like that, you'll see words like probation, suspension, or dismissal.
And the rules that govern all of these are usually in a student handbook, the code of conduct, and specific policies for these things, such as academic dishonesty or Title IX. Again, these handbooks and code of conduct can be found at the school's website. Now, here's something that surprises a lot of people. The standard of proof in many college discipline systems is not beyond a reasonable doubt, like in a criminal court, like we see on TV. It's often the preponderance of evidence or something similar, which essentially means more likely than not.
Yeah, that's right. And the process is not a criminal trial, even though sometimes it can feel that way. You might have advisors instead of attorneys, limits on questioning, and rules about what evidence can be considered, but those rules can be very different from what they would be in a criminal trial. But the consequences, like suspension or a finding of responsibility for academic dishonesty, can have very real impacts on a student's life and career.
I agree. Now, what due process really means, we hear that a lot. People hear the phrase due process and they imagine a full courtroom with a judge and a jury. In school discipline, due process looks a little different. At a high level, what does due process usually mean in this context?
You're right. It's different. In simple terms, it means that you should get notice of what you're accused of specifically, and then a meaningful opportunity to tell your side of the story before any major decisions are made regarding your case. In K through 12 public schools, that usually means the school needs to tell you what rule they believe was broken, and give you a chance to explain, or give the student the chance to explain. For more serious consequences like long-term suspensions or expulsions, there are often more formal hearings, or even reviews by maybe the Board of Education or something, the school board. In colleges, due process is usually defined by the school's own policies in their handbook. And they hold as long as they meet basic fairness standards. That would include something like a charge letter, where, again, you're being told exactly what it is you're being accused of doing that broke a rule, what violation you're accused of. Getting the opportunity to review the evidence against you, and then some kind of a hearing or a meeting with a conduct officer, and usually an appeal of that decision afterward.
So, due process in schools doesn't guarantee a perfect system. It means you should not be punished in a serious way without notice and some kind of a fair procedure.
Exactly. And part of our job at KAL is to hold schools to their own rules and just rules of basic fairness when those rules are applied.
I agree. And that's what we do very well every day. Now, let's go back to our fictional students, Maya and Alex, and see how these cases can go wrong when families think, we'll just explain. So let's start with Maya. The assistant principal calls home, says Maya was in a fight. We're thinking about a 3-day suspension. Come in tomorrow to talk. Now, her parents are embarrassed and upset. They tell Maya, you need to tell them exactly what happened and apologize. The very next day they go to the meeting. Maya is nervous. She admits she pushed the other student, but says she was being picked on all week. And in the meeting, there's no real discussion of the other student's role prior, bullying, or what the code of conduct actually says. The assistant principal types up a summary that reads, Maya admitted to physically assaulting another student. Maya is suspended for 3 days. There is no mention of the other student's behavior or any context. Now, Rob, what's the problem with what just happened?
Well, there's a few things. First of all, nobody looked at the paper the code of conduct, the incident reports, whether there were witnesses to any of this. The meeting was just dominated by emotions and a desire to rush to a quick resolution and get this over with quickly. Secondly, the write-up now says Maya admitted to physically assaulting another student, which is much more serious language than Maya pushed another student during an argument, right? That language gives a certain impression that can follow her in internal records at the school. And third, this is very important, her parents didn't know that they could ask questions. What evidence are you relying on of this? What's the history between these students? What's the full range of possible consequences that could be implemented here? And what's our right to appeal? They went in thinking, we apologize, you reduce the punishment, and instead they ended up with kind of cementing a very harsh narrative in this case.
That's true. Now, let's take a look back at Alex. You remember, this is a college student.
Right.
He gets the academic integrity email and thinks, oh, this is just a misunderstanding. I'll just email the professor and explain. Alex sends a long message saying he was anxious about the test. He glanced at his notes for just a minute, and he knows that technically violated the rules, but he didn't mean to cheat. He hopes that honesty will help. Now, the professor then forwards that email directly to the conduct office as proof that Alex admitted to violating the policy. At the hearing, the university focused on that very own admission. Alex is found responsible. He fails the course. He's placed on academic probation, and now it's on Alex's record. Rob, what lesson do we take from Alex's situation?
The big lesson is that just explaining in writing without understanding the consequences can hurt you more than it helps. Students often think they're telling a sympathetic story when in fact they might be making admissions that the school will treat as core evidence against them. Now, we're not telling students to lie. That's never the right way to go. That never works. We're saying get advice before you write detailed statements or messages about an incident, especially if your email starts with something like, I know I should have something.
You're absolutely right about that, Rob. Now, a question we get all the time is, do I really need help with this, or is this minor? Rob, what are some signals that a case is serious enough that families should slow down and consider getting advice?
Well, a few things to look for. If the letter or the conversation mentions suspension, expulsion, removal from housing, or dismissal, that's serious. If the school uses words like assault, harassment, sexual misconduct, threats, weapons, bias, academic dishonesty, that's serious. If the process includes a formal hearing with a panel or the chance to have an advisor, that's serious. If the school says the outcome will be recorded in your student file, on your transcript, or an internal conduct database, whatever, that's serious. And finally, if the situation could realistically affect your future schooling, immigration status, we have a lot of foreign students, especially at colleges and universities, financial aid, or professional licensing, that's serious.
I would agree. Now, if you're unsure whether your situation crosses that line, as Dr. Wright just described, that's exactly the kind of question we can help you answer in an initial screening call. Now, let's talk about what's a good first response and what it looks like when you get that scary email or phone call. Now, you don't need the perfect strategy in the first 10 minutes, but what are some simple steps families can take before they do anything else?
Well, first, pause, okay? Take a breath. You don't need to respond to this in the next 5 minutes. Read the letter or the email carefully and slowly. Take a screenshot of it so that you have a record of exactly what was sent. Secondly, gather documents that might be relevant. Save emails, texts, screenshots, photos, anything else connected to the incident. Don't delete anything, out of panic or something. And third, look up the written policies. Find the code of conduct in the student handbook. Look at the academic integrity policy or Title IX policy that might apply. See what rule they're saying you violated and what process they say they'll follow. And then fourth, avoid sending long emotional explanations. That kind of goes back to what we talked about before. A simple, respectful response like, I've received this notice, I'm reviewing it. I'd like to understand the process and my options before scheduling a meeting. That kind of thing buys you some time without admitting to anything. And fifth, if the case is serious, reach out for advice from an attorney who does student defense work, not just any general lawyer who's never dealt with school procedures, but somebody who is accustomed to dealing specifically with this kind of thing.
Like we do here at K. Altman Law.
Yes, we do.
Now, let's revisit our two students, Maya and Alex, and imagine a different path when their families get help early. Now, in the revised version of Maya's story, her parents called a student defense advisor as soon as they heard the word suspension. They learned to ask for the incident report, the code of conduct section being used, and a list of witnesses. They coached Maya to tell the truth, but in a focused way. And they highlighted the prior bullying that had been reported but not addressed. At the meeting, instead of signing whatever is put in front of them, they asked for a written summary to reflect that Maya responded to the ongoing harassment and that the school is also addressing the other students' conduct. The school still imposes a consequence, but is shorter and balanced by safety measures and a behavioral support plan. Now, Rob, what did early help change for Maya?
Well, it didn't magically make the incident disappear, but it did change the narrative from Maya is a violent student, which is what you had to begin with, to Maya was involved in an altercation in the context of bullying that the school is now addressing. It also ensured that discipline was proportionate and that the school committed to preventive steps, not just punishment.
Exactly. Now, for Alex in the revised version, after receiving the academic integrity email, he calls us before writing to the professor, which is a good thing. We review the policy with him, we look at the evidence, and we talk through his options. Now, instead of sending a confession, Alex sends a short message acknowledging receipts and asking to review the evidence and understanding the process. And then at the hearing, he's prepared to describe what happened without volunteering unnecessary omissions. And we help him to present supporting context like confusion with instructions and the lack of proctoring. And we raise process concerns where appropriate. Maybe the outcome is still a finding of responsibility, but with a reduced sanction, such as a grade penalty without probation, or in some cases, a not responsible findings where the evidence doesn't meet the standard.
Right. The difference is that Alex doesn't lose by email before he ever gets in the room. He makes informed decisions instead of panic decisions.
That is correct. Now, we talked about K through 12 and college as if they're two totally different, separate spaces. But there are places where they intersect, especially when it comes to Title IX and serious misconduct. Now, we're going to have a full episode a little bit later on Title IX later this season, but at a high level. What should families know about how discipline and Title IX connect?
The main point is that some conduct, especially sexual misconduct and harassment, can trigger both a Title IX process, which is kind of a formal regulatory process, and a general discipline process from the school. In schools that receive federal funding, Title IX has its own set of procedures and protections. Those cases can be very high stakes for both complainants and respondents. It's also important to know that what happens in high school can show up in college. There are situations where a college asks about prior discipline or whether patterns of behavior matter later on. Conversely, students in college sometimes face Title IX and conduct cases that have implications going forward for professional programs and graduate schools and licenses, and even maybe attached criminal investigations.
Yeah. So if you hear the words Title IX, sexual misconduct, or harassment in the same sentence as your child's name, that's not something to navigate alone. Even at this introductory level, we want listeners to flag that as a category where early legal advice is critical. Now, before we wrap up with our first episode, Rob, let's boil it down. Okay. If you remember nothing else from Student Defense 101, remember this: school discipline systems are real systems. They have rules, timelines, and long term consequences, even when they are dressed up as, let's just have a quick chat or an informal meeting. K through 12 discipline can affect where your child goes to school next, how they are viewed by teachers and administrators, and sometimes how law enforcement sees them. College and university conduct cases can affect scholarships, housing, studying abroad, graduate school applications, and professional licensing. Now, the worst time to learn how these systems works is while you're already in the middle of them. The best time is before you need them, or at least early enough to avoid preventable mistakes. We put together a one-page student defense basic checklist that goes with this episode. It covers the first 5 steps to take when you get a discipline or conduct notice, key terms to look for, and questions to ask before you walk into any meeting or hearing. You'll find that in the show notes and on the K. Altman Law website. Now, if you or your child has already received a letter or an email or even just a verbal warning that something serious is coming, our team at K. Altman Law is available to review your situation and help you understand your options. We handle matters across the country, but laws and procedures vary by state and by institution. So getting advice specifically to your situation is important. Rob, any final thoughts for families who are hearing all of this and thinking, I wish we had known sooner?
I would just say this: you're not alone. You're not the first family to be blindsided by a system nobody explained to you. You're not the first university student to have something like this surprise you. You don't have to become an expert in this stuff overnight. You just need to take a breath, get the right information, and make the next decision with your eyes open instead of just in a panic.
Thank you, Rob. Now,
Thanks.
in our next episode, we're going to zoom in on K through 12 discipline, suspension, expulsion, and alternative placements. I know you mentioned that earlier. And we'll talk about what schools can and cannot do, what your rights are, what rights your child has, and how to respond to them when someone says, we're thinking about removing your child from this school. Now, if you found today's episode helpful, please subscribe to Legally Blind Justice. Leave a review and share it with another parent, caregiver, or student who might be facing a scary letter from a school. I'm Dr. Amanda Stewart. Thank you for listening and have a great day.
Thank you.